Good evening, all. Thank you for joining us tonight for the Select Board-led Short-Term Rental Subcommittee. I'll call the meeting to order at 6 p.m. And really appreciate all you coming to the table here and discussing your proposals for our special town meeting, September 7th.
Wait, hold on.
Yep.
Dave says that he can't hear anything.
I can hear now, Erica.
Oh, you can? Okay,
Yeah, it just wasn't, no sound was coming through for a little while, but I'm good now.
okay.
Thank you.
Yep, that's good. That's good. Really appreciate everyone coming to the table and just any members of the public who watch either now or later. It's just so everyone knows that myself and Malcolm for the select board are here. And then a couple other folks who were invited, which I'll go through a list. And then two people were designated from each citizen warrant article to come and discuss their article with the group tonight. And that would be Grant Sanders and Jim Solzer for the one, Stephen Cohen and Stephen Morey for Stephen's article, and the other two would be Matthew Peel and Charity Benz for the other article. We also have Pamela
Parent,
here for her general bylaw article.
yes.
Great. John, also on Zoom, we have town council from town council's office, John Giorgio and Devin Braun, his associate. We also have Dave Iverson, chair of the planning board, John Hedden from the health department, town manager Libby Gibson, and a bunch of folks from the public are also watching. I decided that for the first two meetings, we have 5 of these scheduled, that we will not be taking public comment tonight or tomorrow night. So we can go through, hash through a bunch of the articles and kind of figure out where everyone lays and kind of figure out what's in the articles. I don't think that everybody in the room has had enough time to truly digest all the provisions in it. So I think we'll be able to hear about that. And with that, I would, as Mr. Giorgio has limited time tonight, I will punt it to him to go over the charts that he has made, which are basically summaries of the articles. And we're going to start also for members of the public and everyone here, we're going to start with zoning tonight, see how far we get, and then move on to the general bylaws at an appropriate time. Sound good?
Sounds good.
Sounds good.
I would just remind everybody, no long speeches, please. Make your points concise.
All right, hopefully everyone can see this chart, everyone online.
We saw it for a minute and then it went off, Erica.
Oh, darn it. Okay, hold on.
Okay, thank you. Well, good evening, everyone.
Okay, hold on 1 second. I'm gonna share it to the others.
Was that chart in the packet?
It was not, it came in today, Jordan, so, I can email it to you in the morning. Anybody who wants a copy of this, you can. Okay, I'll email it to you.
I did email it to the petitioners of the 3 zoning articles earlier today. I hope you got that. Okay, so we have 3 STR zoning citizen warrant articles, and I'm going to use shorthand here. There's one by Grant Sanders and his group. There's one by Charity Benz and her group. And then there's one by Stephen Cohen and his group. Okay. So what I had done was I asked all the people that I spoke to see their way clear to using the same format for the zoning amendment. And they all did that, which I very much appreciate. And so the zoning amendment is divided into 3 different parts. The first part is we're adding a definition of short-term rental to the zoning bylaw. It happens to be the same definition that is in the general bylaw. Okay. And then we're also adding a definition which I've entitled accessory short-term rental, which is a short-term rental that basically complies with this new section 139-38. Okay, and I'm going to be referring to that section as the substantive regulations, and they do differ considerably among the three different proposals that we received. So again, two new definitions, short-term rental and accessory short-term rental. And I know Grant had sent me an email a little bit concerned about using the term accessory, and he was asking whether we could use another term such as vacation rental. And I think we should talk about that. I don't really see a downside to that, but that's sort of a detail that we can get into later. The second part of the form that I provided amends the use chart. And in Grant and Stevens versions, they insert a Y in all zoning districts except the CI district, with a note that says, subject to the requirements of section 139-38. The Charity Benz Group was a bit reluctant to use the Y designation. And I don't mean to speak to them for them, but I think it was a concern over whether or not that's going to seem too permissive. And I had originally drafted these with an A designation, but in speaking with Leslie, the director of planning, she felt pretty strongly that we should use the Y designation in order to avoid any confusion, because accessory is a defined term in the zoning bylaw, and it essentially says it has to be incidental and subordinate to the principal use. And that's a bit problematic. I can see why that would be problematic. And I think it could create an interpretation problem with the bylaw. So both Leslie and I are recommending that we use the Y designation, subject, as I said, to Chapter 38, Section 38, excuse me. And the important thing to keep in mind here is that because this new Section 38 is part of the zoning bylaw, any change in the future to those substantive regulations would require a 2/3 vote at town meeting. And that is unlike a Stevens article at the annual and the short-term rental work group's article last November. They both referenced compliance with Chapter 123, which is the general bylaw. And I think one of the concerns that I heard repeatedly was, well, you can amend the general bylaw by a simple majority vote. And so the way we've set this up, the substantive regulations will be mostly in the zoning bylaw. And so a 2/3 vote would be required in order to change those substantive zoning regulations. Okay, so that's the basic structure. And if you could scroll down to, so the applicability of and that's accessory short-term rental, ASTR. In Grant's version, they're allowed in all zoning districts except the CI district. In Charity, approaches it slightly differently, and she says they're only permitted in residential districts, which is a defined term in the zoning bylaw. And then Stevens also says it's allowed in all districts except the CI district. So we're pretty close on that one, I think, and at least in principle, I think we're very close. Okay, if you go to the next one, now this begins really the substantive requirements. Grant, the issue here is the total number of rental days per year that anyone can rent their lot or their dwelling unit and be considered an accessory short-term rental. Grant's proposal is the owner must reside on the lot or another lot in Nantucket at least 30 days a year. They don't have to be consecutive. And we're going to get into this issue of ownership and primary residence. And we have to be very careful what terms we use in order to avoid a challenge under the Commerce Clause. But essentially, Grant's proposal, and I hope it's okay if I just say Grant's proposal. We know there's a lot of people that I think worked very hard on all of these three proposals. But in any event, the flaw is you have to own or reside in the property or on a lot, another lot in Nantucket at least 30 days non-consecutive per year. Charity takes a different approach. The lot must be a residential use, which is defined as occupied by the owner or tenant at least 32 days per calendar year. And if you meet that requirement, you can short-term rent up to 28 days a year. So that is different because it places, unlike grants, it places a limit on the number of days you can rent, assuming you meet that, what I'll call the occupied threshold. In Charity's proposal, you can get more STR days if you occupy the premises for more than 32 days per year. So for every additional 28 days you occupy the premises, you get an extra week for a short-term rental. Stephen takes a different approach. And by the way, if I get any of this wrong, I'm more than happy to be corrected. Devin and I have been working very hard on this since Thursday. Well, was it Thursday that we got these? And just putting them all together was a bit of a challenge. Anyhow, Stephen's proposal, as I understand it, is you can short-term rent your property as long as it's less than half of a calendar year. So 180 days, up to 180 days. And so Stephen also has a provision, and this is where we're going to overlap with the general bylaw, that provides special treatment if it's your primary residence. And we have an issue with that because I think it's pretty clear under the body of case law now, if you try to distinguish or give special treatment to one's primary residence, there's a lot of case law now saying that violates the Interstate Commerce Clause. Grant uses the term owner, and that requires the owner to reside on the premises. And that is not as problematic as Stevens, but we're generally recommending more of the approach that Charity and her group are taking, which is it's an owner or a long-term tenant or the operator. So we want to make clear, we don't want to do all this work and just have it thrown out by a federal court down the line. So we want to avoid the interstate commerce issue. And Peter, I see you're on the line. I did get a copy of your email today, and I know the position you've taken all along. But Devin and I are going to make sure, hopefully, that whatever the final version is not going to raise that issue.
And
Now,
you're talking about Peter Howard, right?
Peter Howard, yes, I'm sorry. Okay. Now, the next issue is, and we're going to do a deep dive into all of these, but I just want to sort of go through this chart first, if that's okay. Then there's in terms of the limit on the number of accessory short-term rentals by any person. So Charity says it's one, so each person can have one short-term rental.
Not charity.
That's grand.
I'm sorry, that's Grant, excuse me. But if a person operates more than one on the effective date of the bylaw, they may continue to do so for a period of 5 years. That's the so-called sunset clause. And I think that's okay, but we're continuing to consider that how that sunset clause would actually work. In charities, there's no limit on the number of short-term rentals a person can operate, other than that they'd have to have multiple dwellings, obviously, as I mentioned previously. And there's no limit in Stevens. Okay? Now, the issue is you have to requires a valid certificate of registration from the Board of Health under Chapter 123. And Grant's version clearly says yes. Charity's version actually adds a new registration requirement to the zoning bylaw. And we think that should not be in the zoning bylaw, but it should be in the general bylaw, because that's where all of the Board of Health registration requirements appear. Stephen says, yes, you have to have a certificate of registration, but not until May 1st of 2025. And I assume that's in deference to the issue of getting the registry up and running and giving people adequate time to get their properties registered. There's a minor technical.
Stephen, yes.
Yeah.
There's a minor technical issue, Steve, with your reference to section 123 of the code, and it should be chapter, but that's easily addressed. And all of them say, now, well, except Stevens, but the other two say, you've got to comply with chapter 123, what's ever in there in terms of the general bylaw requirements. And that is the approach that the short-term rental work group took, and that Stephen took in his Article 59. The important difference here, though, is in addition to having to comply with Chapter 123, all of these bylaws, zoning bylaw proposals, also require compliance with the new Section 38 of the zoning bylaw. So there's two levels of protection there. And the zoning bylaw can only be changed with a 2/3 vote. The general bylaw could be changed in the future with a majority vote. And we think those are two very important safeguards that we've heard over and over again about concerns in terms of what can happen in the future. So this approach is going to provide the highest level of security, if you will, that once the zoning bylaw is adopted, no one can backdoor through a general bylaw amendment a weakening of these requirements, because the main ones, the most important ones, will be in the zoning bylaw. Okay? If we can scroll down. That's good. So, is there a limit on the number of dwelling units that can be short-term rented on a lot as an accessory? Grant is 2 dwelling units per lot if rented to the same person. And we had a question, Grant, about that. And does that mean that the same person must sign both rental contracts? I would imagine there are circumstances where somebody wants to take his children on a beautiful Nantucket week's vacation, but they have a big family, so they're gonna rent two dwelling units on the same lot. And so we just want to make sure that we understand this. Let's say I take my family. Does my name, do I have to sign both rental contracts, or can another family member sign?
We're, we're open to any kind of amendment that needs to
Okay.
be to that.
Well, that's what I figured, Grant. So we just spotted that. So here's a big one, the limit on the number of rental contracts. Okay. All three address this in one way or another. Grant's article says you have a maximum of 6 rental contracts during July and August. But if someone either constructs a new dwelling unit or purchases a dwelling unit after the effective date of the bylaw, the maximum during July and August goes down to 4. And this is sort of a bit reminiscent of the work group's article back in November. And outside of July and August, Grant has no limit on the number of contracts. Charity takes, again, a different approach. No more than 8 changes in occupancy per year. And by the way, rental contracts and changes in occupancy really are the same thing. The state statute, Chapter 64G, refers to them as changes in occupancy. And so I guess ultimately we should probably stick with that rather than talking about rental contracts. Now, Steve takes a totally different approach. He doesn't put it in the zoning bylaw, but he puts it in the general bylaw amendments. And let me just say that the major difference between Stephen's approach and the other two is Stephen is putting a lot more substantive regulation in the general bylaw, which from a legal standpoint, for the most part, is totally fine. It's just a question of how you all want to approach this. And in his general bylaw, he limits the number of rental contracts to 9 during July and August. So that's 3 more than Grant. And as again, Charity just says 8 changes in occupancy per year. Okay, can we go down? The limitation on the length of stay. In Grants, there's no limit on the length or number of contracts outside of July and August. But again, there's this limit of the number of contracts is either 4 or 6, depending upon your status when you started the STR operation. Charity has a minimum stay of 4 days during the calendar year, except in July and August when the minimum stay is 7 days. And it's not addressed by Stephen in the zoning bylaw, at least. I'm not sure about the general bylaw. I don't think so.
It's not.
And then,
John, Steven
So-
says no.
I'm sorry?
Steven says no.
Okay, thank you, Stephen. And then the prohibition on all other STRs. So if you remember, we're putting a definition of STR in the zoning bylaw. And then we're going to do some kind of, we'll just continue to call it the accessory STR. And to be an accessory STR, you need to be an STR, but you have to comply with all those requirements of Section 38. So in order to tighten up the use chart and the use allowances, what we're saying is that other kinds of STRs, meaning those that do not have those same restrictions, are not allowed. Basically, they're going to be expressly prohibited. Okay? Now, if we go down to other, yeah, thank you. So Charity has a provision that says when the lot is owner occupied, there is no limit on STRs except for the minimum stay provisions, the 4 and the 7 days. Okay? And so that provision, I think, is intended. Well, I'm not sure what's intended there, but I think, well, on the surface, Charity's proposal might seem pretty restrictive. I think this provision opens it up for at least those properties that are owner occupied. Then you could rent all year and all summer. The only restriction would be the length of the rental contract. Where, again, we're a little bit concerned about using the term owner occupied. And so what we want to do here is we want to make sure that we don't have too restrictive a definition so as to run afoul of the Commerce Clause. Okay. Is that it? Erica? I think that's it.
Yep.
So they're all very interesting proposals. I see definite avenues of getting to yes on a single version. But it's going to take compromise on everyone's part. And the little speech I'm going to give now is it's really, really important to get to yes, at least to get 67% of the voters to yes. And so whatever we can do, I think the approach here should be, because these 3 articles go on the warrant exactly as they appear in the petition. There's no way to change that. So I think the vehicle, we have 2 options here. The first option would be for the select board / planning board to sponsor an article that represents a consensus among the 3 groups. And also that from a planning perspective, the planning board thinks is good, sound planning. And we just put that article on the warrant before the deadline for closing the warrant. The other option is to do what we did with Article 60 at the annual town meeting, which is to produce a motion under one of these articles, or even under a select board / planning board sponsored article. We draft a motion that everybody can agree on, and then we indefinitely postpone these other 3. Okay? So that's pretty much, Tom, the landscape on zoning. And I don't know if Pamela is on. Is Pamela on?
She's at the table. Yes.
Hi, Pamela.
Hi.
So I just want to talk very briefly about the general bylaw amendments, if we could put that one up on the screen.
Yep, give me 1 second.
And again, we're going to do this relatively quickly, but I think it's important that everybody see the different approaches here. And while Erica is getting on the screen, Pamela had a very particular interest in essentially tightening up the definition of corporations, and also making sure that we prohibit other kinds of ownership, partnerships, real estate investment trusts, or similar entities. I don't mean to put words in Pamela's mouth, but hers is a very targeted, specific amendment to Chapter 123, and she doesn't really address, which is fine, sort of the use provisions in zoning and how 123 and zoning would sort of interact. Hers is really standalone, and so I'm not sure she doesn't really have to participate in these discussions because her article, I haven't seen anyone who has submitted a proposal that differs from what she's proposing in terms of the definition of corporations and capturing those other entities.
But I would like an opportunity to explain why I am doing that, why.
Yeah, we'll give you that opportunity, no problem, Pamela. So, so it's important to remember another thing here. Chapter 123. Now, well, it doesn't now. I mean, at town meeting, we inserted a prohibition against corporate ownership, right? That's pending with the Attorney General. I believe it's been submitted for approval. I have no reason to doubt that the Attorney General will approve that amendment because she has done so in other towns. Okay, so that's basically the first section of the short-term rental. I'm sorry, the general bylaw comparison chart. Now, if we go down to the next one, Erica, as I said earlier, Stephen has a preference for primary residence, essentially giving an exemption from certain regulations if it's the primary residence. And unfortunately, Stephen, this one I think is pretty clearly problematic under the Commerce Clause based upon the City of New Orleans case and some of the other cases that have come down in various circuits around the country. And so I think we need to, I'm certainly not going to recommend that we insert that in the general bylaw. If there's another way to accomplish what you're trying to accomplish without running afoul of the Commerce Clause, then we're going to be all ears to that. Now, if you go down, if you remember in Chapter 123, and let me just remind everyone that Chapter 123 has the basic provisions for registering short-term rentals. And then there's a provision that authorizes the Board of Health to adopt regulations, which the Board of Health has done with the approval of the Select Board. And the bylaw says fees will be determined by the Board of Health, and the regulations actually establish the fee. Charities Group wants to provide a different fee for if the unit is not the primary residence of the owner. And it increases, I think it's from $250 to $350. And there are two issues with this. First is under the so-called Emerson College test, which is a Supreme Judicial Court opinion, and we could spend all night talking about that, but I assure you we're not going to do that. One of the things the town has to do with any fee is you have to demonstrate that the fee reflects the cost of providing the service. Not dollar for dollar, but is generally a correlation between the cost of the program and the amount you're charging. So I'm concerned about a two-tier fee structure in addition to the Commerce Clause issues here potentially. The town would have to be able to justify how administering and enforcing the short-term rental registration program costs more money for non-residents than for residents. And I'm just putting that out there. That's the issue, and that's something that's going to have to be discussed. Okay, I think we can go down from there. Erica? There's a number of changes to the registration process, what kinds of documentation you have to submit. And, there are differing requirements in all, well, I should say in, really, if you put Pamela's aside, Matt Peels submitted and I believe it's in conjunction with Charity, submitted a general bylaw amendments. For example, theirs requires the operator to provide a floor plan showing the STR layout at the time of registration. Stephen puts in a whole bunch of other requirements. And um, and charities zoning bylaw has registration requirements. So I think we need to take that out of her zoning bylaw, and we have to look at the general bylaw. We have to look at the regulations to see whether or not it's already covered. And some of these you'll see in our notes are already covered in the existing general bylaw and the regulations. So we don't want to make this overly complicated, and I worry about putting too much in at one time. The bylaw, the general bylaw and the regulations are very comprehensive as they stand now. So that's just a warning. I don't think, and some of these, as I say, for example, in the Peel version, there's already a requirement that the applicant submit a description of the premises, including bedrooms and bathrooms and parking and so forth. So we don't want to overly regulate this by adding new provisions. Okay, if we could go down. Stephen has put a number of substantive provisions in the general bylaw. And he does have July and August, a limit of 9 contracts. Each certificate has to provide for the maximum number of occupants. This is already addressed in the STR regulations promulgated by the Board of Health. He also includes some other provisions which we did not find to be problematic. Whether they're necessary or not is a whole nother question. If we can go, Erica, to changes to enforcement. So this gets very, very complicated. And unfortunately, Mr. Peel's general bylaw doesn't quite get it right. And let me explain. When I drafted Chapter 123, the enforcement section initially, I wanted to make sure that the town had the entire range of enforcement options. And so all of you, I'm sure, are familiar with fines, not that you've ever been fined by the town, but bylaws provide for fines. Under state law, however, that fine cannot exceed $300. But the short-term rental statute says that towns can provide in their regulations a civil penalty of up to $5,000. And that was approved by the Attorney General. And so we don't want to mix up fines and civil penalties. And that's all explained in my comment there. Section 5D of Chapter 123 already contains the $5,000 civil penalty per violation. And a civil penalty, the way you collect on that is you send, so somebody, I would say you reserve that for the really bad actors. And if somebody is just flat out renting their property, for example, without a certificate of registration, you can fine them $300 per violation, but you could also send them a notice, assess them a civil penalty of $5,000 per violation, and demand that they pay the town. If they don't, then the town has to go to court to collect that civil penalty. Whereas a fine of $300, you can enforce through just writing a ticket called non-criminal disposition. The Peel version also includes a suspension of the certificate of registration. That's actually already provided for in 5C, so I don't think that's necessary. And then further amendments to the so all of these, probably when the dust settles, we're going to have to do a careful review of the Board of Health regulations and make sure we've captured everything that people think need to be in those regulations. And I would submit we would wait so that Malcolm and his board doesn't have to do this multiple times. Let's see exactly what passes, and then we can work on a new set of regulations. The Peel article directs the Board of Health to dedicate one employee to inspect STRs and ensure compliance. And we actually think that's problematic because the decision about how to staff town administration that's a function of the town manager and the select board and ultimately the appropriation process at town meeting. I've been at any number of meetings where it's been represented that the town is going to collect all these fees and they're going to hire staff, both probably consultants and maybe full-time employees, that are actually going to enforce these regulations, the bylaws and the regulations. And that's one of the issues we have to be concerned with. We don't want to put anything in that's going to be impossible to enforce. Okay. But we don't think the general bylaw should be directing the Board of Health to actually hire staff. I don't think a bylaw can do that, first of all. And I think we need to leave it to the good judgment of town administration and the select board to come up with a enforcement scheme, an administration enforcement scheme that's actually going to work. That's the town administration's job, and I think we should leave it there. And then Stephen has a provision that authorizes lessees and subleases that are entered into with a valid certificate of registration. Can you scroll down there, please, Erica? Basically, to honor a certificate of registration that applies on a property to allow that to be honored by sublessees. Stephen, again, in the general bylaw, has a limit on the number of the number of certificates of registration, and it's no more than 2. And this is a really interesting question. Should this be in the zoning bylaw, which the other 2 have, or should it be in the general bylaw? Not that you always compare yourself to other towns, but Provincetown, for example, has a limit of 2, and that's in their general bylaw. But it can also be in the zoning bylaw. So that's something you all are going to have to hash out. And then Stephen also has a provision about prohibiting advertising for STRs. And that actually is already in the Board of Health regulations. Okay, can we keep going? Stevens has some beefed up. Actually,
That's not what.
that might be grants, I think. No?
Charities.
This is charities.
Oh, that's charity. I'm sorry. I put that in the wrong column.
It's Matt.
Regulations prohibiting online street parking, etc. So that should go in the column next door.
Yes.
Sorry about that. Yeah. Okay. So that's the overview of the general bylaws. I think there are a lot of decisions to be made. What goes in zoning, what goes in general. But I think the most important provision to get right and to gain consensus are the 3 prongs of the zoning bylaw: the definitions, the use chart, and the substantive regulations. And that's why I recommended to Tom today that we should address that first and then see where we are with the general bylaw provisions, what we need and what we don't need. Okay?
Got it. Sounds good, John. Thank you. When we were speaking today, we talked a little bit about how this issue has evolved in the Commonwealth and other places. Would you just kind of quickly, in the most broad sense, just talk for a minute about how that court cases are still evolving this and that the ground has changed, shifted over this over the while?
Yes, so I was a little bit concerned, Tom, at some of the discussion I heard at town meeting, both formally and informally, which was essentially the Board of Health should just solve this problem in the remand hearing. I know that's a shorthand way of saying,
ZBA.
but I'm sorry, the ZBA. Yeah, the Board of Health has enough on their plate. The ZBA needs to basically, in the Ward case remand, needs to deal with the accessory use question that Judge Vey posed. And I would encourage everybody to rethink that approach, because the only thing, the ZBA is bound by your existing zoning bylaw, bound by the definition of accessory use, bound by the subordinate and incidental standard. And and I'm not saying they're going to do this, but if the ZBA said, well, the great property that qualifies as an accessory use, I bet you bottom dollar there'll be an appeal of that, and we'll be back in court in front of Judge Vey or potentially another judge, arguing the subordinate and the incidental and subordinate standard. And there's nothing the ZBA can do to avoid that. And there are other cases out there where the same thing is going to happen. This problem demands a legislative solution, and that is coming to an agreement by a 2/3 vote of town meeting to amend the zoning bylaw to address the use. There are lots of other towns that are now dealing with other court cases. There was a recent initial decision in Mashpee where the question of what can you do by general bylaws and what you can do under zoning in the short-term rental context, that's an issue in a Mashpee case. We've gotten challenges to fee structures and whether or not they are in fact meeting that so-called Emerson College test. And so this is a very fluid situation. We continue to get cases on the Commerce Clause at the federal level all around the country. So we're going to do the best we can to guide you based upon what we know at the time that we know it. I'm not sure if that's what you were getting at, Tom.
Yes, exactly.
Okay.
That covered that. So I think we have John for 12 minutes before he has to head off and his colleague is here. But I think if any member of the groups has any questions for John on what he laid out in the presentation. Yes, Ms. Benson.
I just have one because, sorry, Eric was coughing.
I'm sorry.
And there were 3 prongs: definitions, use chart, and I didn't catch the third one.
John, did you catch?
I'm sorry, Charity, I didn't hear a question there. I apologize.
And
So
substantive requirements.
Substantive requirements? Okay.
Yes.
the 3 prongs of the zoning that you pointed out, John?
Yeah, adding new definitions is the first.
Yep.
Yeah.
Changing the use chart is the second. And the third is adding a new section to the zoning bylaw, which would have the substantive regulations applicable to STRs.
So that would be 38.
Yes, correct.
Yes, Jim.
Very quick question, John. Thank you for working with us. On the requirement for a 30-day residency and whether or not it violates the Commerce Clause. Of course, it's been in effect for 10 or 12 years in Palm Springs, California, but more recently and more appropriately in West Tisbury, that was approved. Do you know if that has been approved by the Attorney General, their stipulation for that?
Devin, maybe we can take a look at that and have an answer. I don't have an answer for you now, Jim, but we can Devin can certainly take a look at
That could
that.
give us a heads up on it and how how the Attorney General is looking at it.
Yeah. And I just want to let you know tomorrow, I'm actually in Milwaukee as we speak, and I don't know if you can hear the thunderstorm, but we're having a good old Midwest thunderstorm. I can get to the airport early and go to the lounge and maybe sign on tomorrow as well before my flight. So I will try to do that, but otherwise, Devin is going to be on. And I think it would be helpful tonight to, if you want to pose any sort of legal questions about the Commerce Clause or enforcement and fines and civil penalties, that would be good. And then, we can be prepared to answer those questions perhaps tomorrow night.
Sounds good, John. Are you gonna pop off now?
I can stay another few minutes.
Okay, any other questions for John or anybody from staff, et cetera, who has any questions for John? No? Any? Oh yeah, I'm not taking both, we're not doing both, that's for the 6th.
Just happy birthday, John.
Thank you. All right, well, I'm going to sign off then, and good luck with your discussions, and I'll be participating as we go along. Devin's going to keep me very well informed of everything that's said tonight, and if anybody says anything mean about me, she's going to tell me tomorrow.
Thanks, John.
All right, thank you. Bye, everyone.
So I think for the rest of the balance of the meeting, we'll ask the 3 zoning petitioners to kind of describe their article and to kind of go through provision by provision, just generally kind of what their thinking was. And something that I've been thinking a lot about is in the articles that we've proposed in the short-term rental work group, et cetera, there's the beginning of the bylaw that has the purposes and intents, which is the rational basis, which is how the Attorney General looks at it. And certain things that we talked about at length on the short-term rental work group were things like churn and protecting Nantucketers' rights to rent and all the other things. And I think it would be helpful if you so wish to sort of define it as that, because I think that is kind of the lexicon, if you will, that a lot of people are thinking of a lot of these provisions. So if you so elect, kind of tie it back to what your rational basis is, if you will, to use the legal term, for what the provision that you're proposing is. Should we go alphabetical order? And Ms. Benz and Mr. Field to start on going through their article a little bit, just on the zoning piece for
Okay, the primary purpose of our article is to protect residential neighborhoods and keep commercial SDRs out of them. We would like to be able to be sure that
Can I just make a note, since there's no mics in here to be
Oh.
amplified, we just need to speak a
Yell?
little louder. Yeah,
okay,
thanks,
should I start over?
if you want.
Okay. Our primary goal is to protect neighborhoods, residential neighborhoods against exploitation by unlimited short-term rental property. Nobody wants to have a house, a short-term rental next to them. We've learned that over and over. We want people to be able to maintain the enjoyment that they've always had with their properties in these neighborhoods. We want to, and you can see from some of the articles, other articles, I think, we want to try to help them avoid hollowing out of their neighborhoods so that they're essentially going into a ghost town sort of environment, and its encroachment takes place in these neighborhoods if it does. And we felt that the article that we proposed encourages long-term rentals, which is something that we have lost, and it is damaging the community. It's sending people. I can give you an example. My dog groomer had to leave, got thrown out for a short-term rental, the property to be, so all those dogs that you see in the area are going over to Hyannis or Bourne or someplace else to get groomed. And we've also heard that some of our local residents are having a hard time competing with offshore investor sort of STRs. They, you know, and it's hard on them, and not everybody can afford a swimming pool. We've had in our group 2 people who have lost contracts because the potential renter decided they would up the ante and want a place with a swimming pool. We feel that our article complies with the Bay decision. And we think that even though secondary dwellings started as being used primarily for year-round residents to be able to defray the expenses of mortgages and insurance and so forth, that use has changed. And now those are not, and that is in the zoning, that definition is in the zoning bylaw. And we've seen that over the last 4 years, the people who live in these neighborhoods don't want to have businesses running in their neighborhoods. And so that's why we've written what we've written, and they have for 4 times now voted down the attempts to bring businesses into neighborhoods, and that's what we're trying to do with our bylaw.
Would you like to go through any specific provisions and how you think that defines into what your statement of principles are?
Sure. I think John's suggestion that we try to format these identically is very good. All right.
I think it'd be just helpful for the members of the public to, as they watch, to kind of get a bullet point of.
We refer to lots and their use. We don't refer to owners. We just, it's a lot. And if a lot is used for residential use, and this does not have to be consecutive days, it will automatically earn 4 leases. So any property owner who is in their residence for 32 days, which equates to a long-term rental, automatically gets 4 weeks of short term. Everybody. For those people who want to live here or who spend a lot more time here, for every additional 28 days, they get another week. Short-term rental. So that's essentially what we feel will not only, if you have an owner on the lot, sort of supervise and be on the property. And the other thing is we also include long-term rentals as part of that 32 days. So if there's a long-term rental, that counts for another week of short-term rental. We do say that if there are on these lots that have say a primary and a secondary dwelling, the accessory short-term rental limits would be 1 dwelling at a time, not both dwelling. And as you heard, generally July and August, minimum stay is 7 calendar days. All the rest of the year, it's 4 calendar days as a minimum stay. No more than 8 turnovers of contracts, and then going into the business of, what everybody else has that you have to put out. Everybody has to register with the town and operate their short-term rentals in accordance with general bylaw 1, 2, 3. And then there's an exemption. All accessory short-term rentals occurring during any time when the lot is owner occupied shall be permitted as of right and exempt from the limitations set forth, which I just mentioned, except that subsection 1D shall apply. And that has to do with the minimum stays, and that's to address the matter of churn. And then John suggested that we move number 3 of our article to a general bylaw, and I think that's probably something we can do. All other short-term rentals in residential districts are prohibited. And for the purpose of this section, only residential use shall be occupied by the owner or tenancy of at least 32 consecutive days in any calendar year without someone.
Anything to add, for your?
I mean, I think, Sherry hit on the bullet points and everything. I think the one thing I'd like to add, can I go back? The beginning there is, I saw the ZBA meeting today and everybody talks about a long history of the rentals on Nantucket. Well, nobody's talking about the long history of the year-rounders on Nantucket. And we have a very strong and long history of a year-round community here. And I think it's important to protect that. And so, and our article really does that. The island has definitely changed. I think it's important to protect the economy as well. Yes, it's.
Sorry, yes, Dan, did you call?
Let me. mute him.
The island's changed. We want to keep short-term rentals going. We're not trying to regulate that or, put them out of existence or anything like that by any means, but we need to, I think, kind of curb it a little bit and get back to a little bit of a good year-round neighborhood. And I think a lot of people miss that. And a lot of people miss that community of this island. And I don't want to see it go down a bad road. It's more for the future for me, for this island.
I'd just like to add one thing that in our group, there are 2 people who live on a street with absolutely nobody in the adjacent homes. The entire street, except for this one person, is a short-term rental. There is no one there in the winter. And that's not the way Nantucket has been and shouldn't be in the future.
Got it. Before I turn to Mr. Cohen and Mr. Maury, Dave Iverson has.
Yeah, I just wanted, if I could, through you, ask the proponents a question. And I guess it's a question to see if this is something that they're willing to move from, if they're flexible. I noticed in their article that they max everyone out at 8 changes of occupancy. Is that correct, Charity?
That's what's in our article.
Okay, so I guess my question is this, because I think there's a number of people that I would consider the gold standard, right? They rent off season to teachers, doctors, whatever, for the whole winter. And then when they're done with that long-term rental, let's say it's 6 months or even 8 months, they are then restricted to only 7 turnovers. So I'm just wondering if you're flexible in that, because I think that's the gold standard that we're trying to, and you guys clearly are trying to support that sort of rent. So I'm wondering if you're flexible on the 8 turnover.
They're renting for over 30 days. I don't think that is considered a short-term rental, therefore it wouldn't be considered a change of occupancy under our article, would be my understanding.
So, but then they would still be restricted to 8 changes of occupancy, even though they've rented, let's say, 8 months.
I don't think that's correct. I don't know. I don't think that would be interpreted as under a short-term rental occupancy change.
But you've restricted to 8 changes of occupancy, no matter how much you use or rent your house, correct?
Let me read you an example, Dave.
Okay.
A lot is rented to a teacher for 9 months.
Yep.
From October 1 until May 31, 273 days of residential use.
Yep.
May be used as an STR for 12 weeks of the calendar year, 4-week allowance plus.
Oops, I lost you for a second.
For each of the additional month of tenancy by the teacher.
Charity,
Capped at 8.
can you back up? You fluttered out on me for a little bit. Do you mind just repeating? I didn't catch it all.
A lot is rented to a teacher for 9 months, from October 1 until May 31, 273 days of residential use. The lot may be used as an STR for 12 weeks of the calendar year, 4-week allowance, plus an additional 8 weeks for each of the additional month of tenancy by the teacher, but the use is capped at 8 turnovers. In a situation like that, you know, they could rent it as STR for 8 turnovers, but they have residential use for all the rest of the time. And a long.
Okay. All right. Well, I would urge you to reconsider that, because I just think that if they're renting long-term to somebody that we really need to rent to, that they shouldn't be capped in how many STRs they have for that limit. If the long-term is the principal use, they shouldn't, I don't feel, and I think that you would get more people to buy in if you allowed more rentals after that long-term period ended. But that's just my opinion and my question. So thank you very much.
Thanks, Dave. Anybody have any other questions for Ms. Benson, Mr. Peel? Stephen.
Sure, I'll take it if that's okay. I guess what I would say is I think that there's a general agreement on most of what Matt and Charity said in terms of their goal. Frankly, I think there's a serious disconnect between their goal and the rules that they proposed, and I think that there are serious unintended consequences and negative impacts of that. And I know now is not the time to sort of like drill into those details, but I have some serious concerns about what the actual rule that they proposed, how that would play out. And I think it has some really negative things that are actually the opposite of what they suggested. But for now, I'll stick with mine. So I would say I've got a list here of regulatory purposes and regulatory goals. And I would say that preserving the tradition and culture of private home rental as a primary way for visitor accommodations, as opposed to hotels and resorts. I think we all know there's only 1,000 hotel rooms on Nantucket, and nobody really wants a proliferation of resorts. And so we want to keep our visitors in private homes. And right now there's 20 to 50, 60,000 people coming in the summer, and they have to go somewhere. So the question is, how do we put them in a place without having negative impacts? Providing reasonable protection for property rights and financial decisions of existing owners. So both locals and summer people who have purchased homes with the expectation that they would be able to have some rights in those. Should those rights be unlimited? No, but should they be protected in a reasonable way? I think so. Limiting the impact of short-term rentals on neighborhoods by addressing the nuisances that are created by short-term rentals that might be different than non-rental users. Limiting the impacts of STRs on neighborhoods and the real estate marketing by limiting the expansion of STRs so that we don't have a ghost town of houses and that are just STRs. Limiting the impact of STRs on neighborhoods by limiting investor-focused STRs. I think there's a broad agreement that, you know, people who are not invested in our community are not, you know, we want to try to discourage that a little bit. Preserving neighborhood integrity, I think, is important, and creating community benefits in exchange for STR licenses. So if you're going to do an STR, well, what improvements do we not otherwise require that we might want to require of an STR owner? The goals, I think, are the following. The number one, ending the divisiveness that we have, ending the ongoing debate, ending the uncertainty, ending the neighbor on neighbor lawsuits and complaints. I think all of that has been really, really negative. And I have to say, I'm really disappointed at how the Article 59 and 60 political campaigns went. You know, like I have 3 brothers, so I can take a punch. But seeing my name personally used in fundraising letters and in advertisements that were blatantly misrepresenting what I said and all kinds of things like that. It was it was the politics of personal destruction that we have not seen on Nantucket, and I hope we don't see again. And I hope we don't see going into the fall, because it's not, I don't care, I can take it, but it was just as a general, a really negative thing for our community to see that kind of thing. I'd love to see all these lawsuits end. Neighbors suing neighbors is not where we should be. I think we should be making decisions based on facts. I think we should try to use incentives instead of burdens whenever we can. If you look at the the parts of our zoning code that are the most successful, I would say it's tertiary dwellings and the covenant program and the flex development program. These are programs that allow for bonuses based on providing for affordable housing, accessible year-round housing, open space. You know, give people a bonus for doing the right thing, for create goals, not burdens. Enacting a system that focuses on consensus terms, not outliers. Enacting a system that's easy to understand and easy to comply with. If a real estate agent can't explain it to somebody, and and real estate agents are, professionals who explain stuff, all the zoning code and all kinds of stuff all the time. If someone can't explain it or understand it, we've got problems, and people can't comply with it. So it should be something that's easy to understand and comply with. But it should be easy then for the town to enforce it if it's simple. It should be a robust system, but it should be easy to enforce. We should enact a system that is not invasive and that respects people's personal privacy and safety. I think collecting certain kinds of information is extremely invasive and potentially a public safety issue for what we're doing around here. Telling people, making it public information, how many nights people spend in their houses and how many nights the house is empty and what patterns exist for that, I think is extremely dangerous and invasive. Enacting a system that incentivizes goals that are workarounds isn't any good. If you're just creating like work for lawyers, I don't need that work. I'd rather have systems that are that are simple. And enacting a system that respects year-round community and does not incentivize housing insecurity. And I'll have to say, as an example, the example that Charity just gave, that teachers should do the shuffle, and somehow I don't know what teacher works October to June. That's not the school season, nor is it the teacher contract season. Teachers work year-round, not just the 9 months that the school's open, which I actually think is like September to June. And they start working in August, actually, so they work much longer than 10 months, but creating an economic incentives for STRs that encourages housing insecurity for members of our community is not something I would support. I think we should be avoiding doing that. I don't necessarily want to go through all of the provisions in my bylaw, but I will give you some examples of sort of general concepts that I think are actually something that we could potentially agree on. And I'll try to leave some of the details out and just have them be concepts. So in terms of concepts, I think that we all agree that STRs should not be the primary use of most homes. Most homes should have a less than half year, if not much less than half year use as a short-term rental. I think that we can all agree that there are some zoning districts that shouldn't have STRs, primarily the commercial industrial one, but maybe some others. I think that we can all agree that we should be limiting the number of STR licenses or the number of STRs on a property that people can have. Nobody thinks that there should be unlimited investment potential, and if you limit the number that people can do it, it sort of cuts back on that. I think that having a system that limits the number of turnovers that you can have in the summer is generally a good idea. We want to encourage a limit there, but we also want to make sure that we're not killing the shoulder season. I think if you're limiting reasonably limiting turnovers, you're essentially killing the wedding season in the spring and the hunting and festival season in the fall and the holidays in the fall and spring. Those are generally 3 or 4 day weekends, and people are gonna, if you tell people you can only make your money in 7 or 8 weeks, you better believe everybody's going to do that in July and August, and you have effectively then killed the shoulder season. I think we need to make sure that we are not doing, or I think we should make sure that we're not doing that. Nantucket has worked really hard to go from a town that had an 8-week season to a town that's April to Christmas, and that is what gives us life year round here. And I think that we need to make sure that we're supporting both the limitations in the summer to stop too much churn, but also not killing off our shoulder season. I think we should be making sure that we have robust rules that require owners to respond to nuisances, or have people who can respond to nuisances within 2 hours. And if they don't, then that enforcement can be held against them for penalties and also loss of their license. I actually think that the adoption of these rules in general and the idea that people could lose their license is the #1 enforcement mechanism we have, because right now there's basically no penalties. You get a noise bylaw violation, $100, whatever, nothing, but if you could lose your license, you better believe people are going to start paying attention to what's going on at their properties, because then they'll have 0 rentals next year, which is what should happen if someone is a problem resource. I think we can look at trying to bifurcate the number of weeks that we allow people, or the kind of rules that we have for people based on how long you've owned the property. So in other words, if I have already owned my property for a certain number of years, I am a member of this community, maybe I need less rules. But if I have not, if I'm just buying the property now, maybe we want more rules, and those rules could make it more difficult for someone to do it just as an investor. If you give them a 3 or a 5 or whatever year period where they have to follow certain rules that make it less tasteful as an investment, then we can deal with that, helps deal with that, but also it doesn't continue forever, right? It screens people out, but then that burden falls away once you have been part of our community for a while. Just an idea. I think that the limitations on turnovers, again, should not apply outside of the summer season, because we want more turnovers for short weekends at that time. We don't want to make it too expensive for people to be able to come here. We want people to come in the shoulder season when they come for shorter times. Nantucket is so inaccessible already, but if people can come in the shoulder seasons for shorter periods, we shouldn't be making it more expensive by making them come for a week. I think we want to look at making sure that there are no STRs in tertiary dwellings or inclusionary housing, which builds off last year's idea of our last meeting's idea of no timeshares or affordable housing. For the same reason, tertiaries and inclusionary housing are not supposed to be for vacation rentals. I would look at obviously requiring compliance with chapter 123 or I would look at adding to the amount of the kind of certifications that people have to show that they've paid their taxes, they don't have non-compliance with septic systems, those kind of things. I do think we need to adjust the existing rule. The existing rule says the certificates of registration are not transferable, which obviously makes sense, but we have so many changeovers during the calendar year where there are leases that are signed up and for after that, and there has to be a net mechanism for those leases to be honored without it being just a transfer of that license. And I think what we don't know right now is it's going to take the town a day or week or a month to issue that license from when it's applied for. And so my idea is that you can honor those leases during the pendency of an application. So in other words, if I have applied for a license, I can honor past leases. And then when my license is issued, then I'm okay. And if I get denied, then, that's the problem. But there should be at least some kind of grace period based on the pendency of the application with the town or something. What we don't want to do is be in a situation where you can't sell your house during a certain period because you've got leases in place. That's not really, there's no governmental benefit to that. I think we should be requiring that the homeowners post rules that they identify in their houses, that they get an acknowledgement from the tenants about those rules, that they verify the identity of the tenants before they allow occupancy, all kinds of things that would help reduce the idea that is this the honeymoon or the bachelor party, right? Like how many people are showing up here? And we often see one in the lease and the other in reality. In general, I think if we end up with a set of rules that allow people to continue to rent their homes, but mitigate the nuisances in those neighborhoods and deter investor-only STRs, we will have a great victory. I don't think that we need a set of highly invasive, overly burdensome rules in order to do that. And I hope that we can find some consensus on getting there. So that's where the group that I'm working with is on these.
Thank you, Stephen. Anybody from the representatives or other invite? Yeah.
Can I just add?
Sure.
If you have those written down.
Yeah.
Could you email them?
I can.
That would be awesome.
I can.
That way everybody's gotta have it as it.
Absolutely.
You don't think everybody remembered all?
I should write down a few of them.
I will email them to you, Erica.
I think at tomorrow's meeting, et cetera, we'll get into more specific provisions, but I think a good overview to kind of exactly where everyone's opening proposal is, because again, like I said before, I don't think all of us have spent enough time with what's in these zoning and general bylaws to know exactly what every provision is. Mr. Sanders, Mr. Solder.
Before I turn my time over to Jim to talk about how our article achieves our goals, I just have to say that I made a terrible, terrible mistake by standing up at town meeting and promising everyone that I would do everything in my power to bring a reasonable solution to the table, because look, here we are.
Still working on the sheet thing.
Well, I'll write a white paper on that and
Thank you.
distribute it to the group. So I was pulled into a group of really dedicated people from all around the spectrum of this issue. A couple of former short-term rental work group members, Jim and John Kitchener. And then also we have Matt Fee is in our group, which is why he's not here, because of open meeting law rules. And we also have Matt Haffenreffer in our group. This idea for our article, really sort of the germ of it came from Matt. We refer to Matt as Smart Matt in our group because there's two Matts in our group.
Which one's Matt?
Yeah, Matt Haffenreffer is Smart Matt. And then Tucker Holland, who understands housing. He understands dwelling units and what's going on. So we've got data people, we've got policy people, and we're really juiced to be part of this process, because from the very beginning, folks pulled me in to build an article that was a compromise article from the very beginning. Something that was simple, something that was understandable, and perhaps most importantly, something that people can vote for at special town meeting, because we've been there a number of times before. So we think our article is a good sort of basis compromise article for this discussion. If we want to use our article as a blueprint, I think there are parts of it where we can go closer to charities stuff. And I think there are parts of it where we can go closer to Stephen's ideas. And just so that you know, as a group, we have met with a bunch of people who are already involved in this process. We've met with Charity and with Peter McCausland, and we met with Emily Molden from the Nantucket Land and Water Council, and we had a call with Emily's attorney, Dennis Murphy, and then we met with David Iverson and Leslie Snell, and of course, Town Council. We met with Stephen and Penny Dye and Stephen Morey, and of course, we got an earful from the 100 people that signed our petitions. And we believe that we've done a lot of the groundwork that this group needs to do to find places where we can all come together, which I think is really powerful. But the one thing that I want to, before I turn it over to Jim, I just want to say, first, we vow to not put any lawn signs up. Okay. Second, our other vow to the community is we're going to make this about ideas, not about people, not about personalities. Charity and I have been friends for years. Stephen and I have been friends for years. I don't want this to be anything but a policy discussion.
You and I haven't been friends.
No, well, we share the same carpenter.
Yes, we're friends. Okay,
So, Jim.
so being in the middle, some people say you're trying to please everyone. Really, you're trying to displease everyone. Shared sacrifice to come to something that makes sense. So our three goals, I think, show that. I really liked the goals I've heard, but we just simplified it down to three. So one is to protect the peace, unity, and integrity of neighborhoods and reduce neighborhood churn, something we've heard about. Second, protect the time-honored tradition of home rentals on Nantucket. And we've tried to analyze that. We can't talk about it tonight, but it doesn't match some of the accessibility discussion. However, it's a very important discussion to talk about. And so we want to protect that time-honored tradition. I've lived here since my wife and I and my family since 1982, seen a lot of different rentals over the years, some of which I don't like. And then finally, we want to discourage, as everyone is saying, investment-only ownership of residential properties for use as STRs. And that's a type of rental that we feel is sometimes difficult to define, but we do believe it falls outside the area of time-honored tradition. And we feel that it's maybe the most destructive of the types of STRs that we can talk about. So I won't do every detail on every provision in our article here, but because John went through it, but I will do some of it. Our first one says no person or other legal entity shall engage in an accessory short-term rental use for more than one dwelling unit at any one time. That's obviously to help to limit the numbers, discourage investor only, but also protect the time-honored tradition of home rentals, which often was one person, one house. We realize it could be defined as one property instead of one dwelling. That's something we can all talk about. We've heard different ideas on that. Second, as John Giorgio read, if a lot has two dwelling units, both may be rented, but as a STR, but basically to the same person or family. That's something that we feel helps to reduce neighborhood churn. We also know in talking to people that some very traditional STRs have had two dwellings on one property. So it's something to talk about, but basically we're trying to reduce churn. That's the reason we put it in. But with all of these, we know we're going to have to compromise. I'm giving a shout out to a few things that, yeah, okay, this might be compromisable from our point of view while remaining true to our core tenets. Third, this is one John brought up. To qualify as an accessory short-term rental use, the owner must reside on the same lot or on another lot that they own in Nantucket for at least 30 days, which can be non-consecutive in any calendar year. This, of course, is to discourage investor-only investors who don't ever come to Nantucket. It's to protect the time-honored tradition of home rentals on Nantucket. I know from my own neighborhood, Back Street, that there are a number of STRs, and the ones, generally speaking, that are less intrusive, less a problem are the ones where the owner is present. Maybe they live there for a month, but they're our friends. They want the neighbors not to be bothered. They really care about the owner. I know that there's no, test that says you love Nantucket or you don't, but we feel if people have a connection to the island, they will be more likely to run their STRs in a responsible way. And this 30 days, which may be challenged on Commerce Clause grounds. I know that our old friend Peter Kahn from the STR group is saying that to himself right now, but it has been in effect in Palm Springs, California for at least 10 or 12 years. It was recently passed in West Tisbury, which is why I asked John if they could check into that. It's whatever we come up with, and obviously we could compromise on this, but it has to do with a connection to Nantucket. We feel that's crucial. Okay, then we come to the two numbers of contracts per summer. We have 6 per summer for people that have already been renting or owning, and for new owners or operators, 4. Again, that's to try to deter or discourage investor-only STR. Someone buying up or building a huge new place as an STR, if they can only rent 4 contracts, they may not try to do that. It may be available as a lot for a year-rounder. Now, maybe that provision could have a sunset itself to it. I don't know, but we have to discuss those ideas. Should it be 4? Should it be 3? Should it be 5? Those are all things we feel comfortable discussing, but we think the policy lever is important. And I know it's hard to get across to the general public, but we're all talking about this now. So I think that's good. Number of rental contracts in the summer to try to keep that number of contracts at 6 or 7 instead of 9 or 12 or 15. That helps to reduce churn. There aren't so many comings and goings. And it also has the additional effect of perhaps discouraging, and we think discouraging, investor only. Now, we also have no limits on number of rental contracts outside of July and August. I think, Steve, you said it really well. This, like I said, my family, we've lived here 42 years. We don't find there's too much churn or too much whatever. In October, we see the weddings happen. We're delighted to see all the weddings, and it's obviously a part of our economy. So we're not trying to limit that because we don't feel it has the same problems that the summer does. And then finally, this is a sunset provision. We noted obviously, one contract per person, whether it's dwelling or property, whatever, but one ability to rent per person. There are many people on Nantucket who set up their family finances under other conditions. Maybe they have 2, or maybe they have 3 separate STRs. We don't know. We feel there needs to be a provision to help prevent economic dislocation for them. Now, one way to do that is a sunset of 5 years, maybe it's 10 years. There would be other ways to do that too, but we want to give people a reasonable amount of time to adjust to new regulations. And that's something we could work on with this group and with town council to do it in a way that's legal. With the overriding goal of one person, one STR. And that is essentially what we've been working on.
Sounds good. Any questions for Grant or Jim? Okay, so I'm kind of thinking the meeting was technically 6 to 8. But I don't know how much real hard policy we can get into in a half an hour. So what I was thinking, if everyone agrees, either now before we adjourn, or feel free to email me or Malcolm some hopes and some hopes for the process and some goals that everyone has for this. I have my own, which I'm gonna share tomorrow, which sort of came up as we were designing this process. And then how best myself and Malcolm and the select board can help facilitate this process. Definitely open to any suggestions on, we have a very tight time frame. We only have 4 more meetings of this. We need to come up with some kind of consensus product, or at least give it the best shot possible, I think. And then feel free to send me or Malcolm or both of us those ideas. Yes, so Stephen, you spoke.
Yeah, I was just gonna say that we have a half an hour, and we have just 4 more scheduled meetings, and I know Malcolm, you can attend at least 1 or 2 at the end of the schedule, so maybe we can dive into what our hopes for the process are.
Great.
So,
Okay.
yeah, I actually think we could do something productive, just to piggyback. So I used to write regulations for the federal government before in a different life, and I have some experience doing this locally. And I think that, I often find that instead of focusing on like what rules you want, it's best, like we just talked about, what are your goals and how do we try to accomplish those goals in sort of like the simplest terms, which we can get into. But I think that probably in 15 or 20 minutes, we could chip off the sort of the main zoning question of, are we comfortable with the idea of creating a category of vacation rental or whatever we want to call it, that would essentially have no rules in it, right? All the rules would be in everything else we'll talk about, but we'd try to have a very simple definition of vacation rental. And then what zones could that go in, either as a Y or an A? Like that issue, I think we could probably try to tackle in a half an hour, and it would really help us then get into the rules tomorrow, if people are
Right,
okay with
everyone
that.
fine with saying late?
No.
Not late, but I think we can.
Till 8.
Till 8.
Till 8.
Till
Oh, I would-
8. That's a 30 minutes,
We could
30
have
minutes.
breakfast sent in tomorrow. Finish it tomorrow.
Like,
Sleep under the table.
Yeah.
if I suspect that everybody here is okay with the idea that there will be a new term called either a short-term rental, accessory short-term rental, vacation. That sort of doesn't matter, but that is essentially a house that people rent for less than 31 days, right?
Wait, I think we're diving way into difficult substantive issues
I think
right
we're.
at the start. And I don't understand why we can't have a more general discussion. We're being asked to agree to something, and I think it's very contentious.
No, excuse me, Ms. Perrin, I think Stephen is just trying to get the ball rolling on because
Well, maybe
one
we
of the
should-
issues on the zoning piece is that it's been really complicated, and we've had multiple iterations of different definitions that have not gone through town meeting for multiple reasons. And I think that that's the major piece on this, is trying to get 67%.
Yeah.
And I think we all kind of came in tonight, thinking certain things about where we're at on that. And maybe just to get, Stephen, feel free to correct me.
Yeah.
Get our thoughts out on kind of where everybody's at on this kind of.
Yeah.
Is it Y, is it N, is it S is it?
I think that's exactly right, Tom, because if you set all of the rules aside and just go with the most basic concept of, is this a use we're going to allow and where are we going to allow it? Like, if we can't get beyond that question, none of the other stuff matters. And so what I would suggest is that, you know, there should be consensus on the idea that we could have a, I'll call it vacation, short-term vacation rental. And that is a simple term that essentially reflects the definition of short-term rental in the statute and in the Board of Health rule, which has no rules in it, right? All the rules are separate. And that is something that will go in the zoning code in some number of districts. Is that, I mean, I think that's a decent
Great.
topic.
I think everyone should just kind of jump in, be mindful of everyone not talking
Yeah.
over.
My,
See, Grant, let me go to Leslie real quick,
Okay.
please.
Yeah, and this isn't really
Leslie.
a substantive comment, but I don't know that everyone, I know I haven't had a chance to review the three proposals. I've
Yep.
seen John's spreadsheet, but I think without everyone having a chance to look at what that new section 38 may or may not include from all the different proposers, it might be premature to have that conversation, because maybe there are some things that people propose that should be in zoning, and maybe there's some things that shouldn't. I don't know, because I haven't,
Well-
seen those in detail, so I don't know if other people have or not.
So I appreciate what you're saying, but I'm not talking about all of those rules, whether they should be in zoning or whether they should be in the bylaw. I'm just talking about the concept of short-term rentals at all. Should it be allowed in the zoning code? And if so, in what zones? And then all the rules we could talk about separately. But if we can't get to the idea that short-term rentals are allowed use and what zones they should be in, right, I think that's a very simple, hopefully simple topic.
so it's a simple topic, definitely, but there are complexities built into it because charities bylaw is a true accessory use bylaw, zoning bylaw, because her accessory short-term rental is subordinate to the amount of time that people can stay on island. Ours is not. That's why we think that a separate, that's why we don't want to call it an accessory short-term rental. We want to call it a accessory vacation or a vacation rental or a vacation short-term rental, because the word accessory gets in the way. And but the other thing I wanted to mention with regard, Stephen, to something you just said was, if we have a really simple zoning bylaw with basically no rules under it, I'm not sure that can pass a town meeting.
I'm sorry, just to go back. That's not, I didn't say no rules. I said all of the rules are they could either be in the zoning bylaw or the Board of Health. They're just not in the definition. Like, the definition of a short-term rental or vacation rental is just a house that you rent for less than 31 days or something simple like that. All of the restrictions then can go in the zoning code or the bylaw. I somewhat don't care, but I'm just saying, like, if we have a simple definition of the use and if whether or not we're allowing it is question one. And then question two is, if we allow it, where? And question three is, under what terms? And I think that all of the articles have rules, and the question is, like, that's I think that's like the third question, all of the rules.
Okay, I will go along with that. I think that's a good idea. The one thing that I'm a little concerned about is we've got some strict zoning bylaws on the table, and then we've got some zoning bylaws that are also provided along with a separate general bylaw, and I wish they could be linked in some way so that we can
They
compare
can't-
apples to
I think they
apples.
can't be-
Could I interject here?
Yes.
I think, I don't want to spend the next 20 minutes arguing about what we should talk about. It's like, deciding if the table should be round or square. I think Steve made a great point. If you listen carefully, he said, no one is going to get any farther until we define essentially what we mean and where do we want these short-term rentals. If we don't get beyond that, we might as well go home now.
Right, the rules don't matter.
I'll agree with that.
And I would say that just one thing is that there's a lot of rules that there's some question of whether they should be in the bylaw or the zoning code, and that's a question we can discuss as we cover each of those rules. I don't think we need to decide it now.
I mean, I think if you go back in history and go with.
One sec, Dave.
And go with what has been defeated. It was always the zoning part. The zoning part, the discussion of, can you put a short-term rental anywhere in the island? If we can't get beyond that, then let's go home. I agree with
I
Pete.
agree with that.
Jerry, I'll go and then go to Dave and then Matthew, okay?
Okay. We have a problem with enforcement on this. And you can write all the general bylaws you want. But if there's no one who is going to have the backbone or the support of the town to enforce them, they're useless.
I absolutely agree with you, which is why I love the fact that this particular issue involves the denial of a renewal of the license, which is the best enforcement you can get.
But you have to have somebody who is going to actually do it.
Yeah, when people apply for their license renewal, if they have a bunch of complaints, they're gonna have a problem. I would equate it less to zoning and more like liquor licenses and food licenses. If you go to the Board of Health and you want to get your renewal, but you've got a bunch of health code violations or liquor license violations, you're gonna have a problem. And I think that's what we're gonna see here. I hope that's what we'd see here. People not being able to get renewals because they're problems. That is much better than trying to get someone to deal with a noise complaint.
And the Board of Health did that last year
No, Dave.
to a well-established restaurant on the sound.
I was gonna say, like restaurants against each other are their biggest watchdogs. Just like hotels. I mean, everybody is watching what every other person is doing in their realm.
Yeah, non-renewal is much better than fines.
Dave,
Can you hear me?
yes.
Yeah, just in an effort to recenter this discussion a little bit, I think what Stephen is trying to say is let's have a discussion about the use and where it's allowed. And the discussion about the operation is a separate discussion, but until we decide on the use and where it's allowed and how it's allowed, we can't have a discussion about the operation, which would be the regulation. So I think that Stephen and Grant are on a good path here. And I think that that's something we all need to agree on. First is the use and where it's allowed and how it's allowed.
So,
Oh, you want to go Matthew and then Stephen?
Yeah, I mean, yeah, I think what Steven's suggestion is a good idea. But I think we need to take even a little bit step further back, and I think Mr. Sanders shared this earlier, his concern is with the name, just to start off. What are we gonna name this before we even talk about use? And one of my biggest concerns from the beginning, since town council kind of started reviewing these articles before we submitted them, was the word accessory in front. Because what's gonna stop somebody from coming in next year and putting primary short-term rental and then trying to define that? And then.
Two-thirds of voters would have to pass that.
Well, yeah,
Define
I
it.
know,
Use,
but I'm saying-
that's what would stop it?
Yes.
It's a major hurdle, that's why we have it.
But yeah, that's what I'm just worried about. That does open up the accessory part there in front of that.
But
There's
now
always
it's a
been one of my
defined term,
concerns.
that's what we're talking about, is creating a new definition. And I agree, it's confusing to say accessory if we don't intend it to refer to the other accessory,
yeah,
but
I mean,
we need to workshop that name. I think we have vacation in there twice.
Yeah, it's gonna be Blue Ant 33 short-term rental. Well, yeah, it could be seasonal short-term rental but you know, short-term rentals happen in December.
I think you have to
That's a
stick
season
with what the state. wants them.
so.
Well,
it-
you can because yours is a true accessory
Yes,
use.
it is.
But
And
ours
say
would
that,
be, ours would confuse the voters, I think, at town meeting if we said it was an accessory, but we're putting a Y in the use term.
Stephen,
So I think that we could put a pin in the idea of what name we call it and just go with the idea for the moment that there's a general consensus that we should add to the zoning code some definition of the idea of renting for less than 31 days, right? With other rules, but at least that's the minimum. That's what causes something to be a short-term rental. It is a rental of a house or property for less than 31 days. And so
Is it 31 or 30? 31.
I think it's less than 31 or less. So if that's a use, whatever it's going to be called, and I'm going to let my branding friend here think about that. What zones would we allow that in? And I think that Grant's article and my article both say all zones except CI. And I think Charity's article says only in other zones, and I don't actually know which one.
Just no
Wh-
residential zone.
So which zones are you trying to keep it out of?
Residential.
No,
Don't keep it
in residential zone. So I guess which zones are you trying to keep it out of? So,
Our preference is to have an accessory use.
Yeah.
And residential, zones, not a Y.
okay, well, so those are two different questions. What, the zoning code is set up so that you have either an A or Y or an SP in each of the zones. And when you say residential zones, what you're actually saying is not mixed use zones. And that actually, I'm not sure is your intent, because mixed use zones are less neighborhoods than residential zones.
Right.
Right? So the reason why I say no CI, and I think Grant, is because CI is a commercial industrial zone and nobody thinks it should be there. But mixed use zones seem to be like C-Tech or V-Tech or, you know, whatever, seem to be, well, why do you want to keep it out of there and only in like the residential only? So I'm a
Because
little,
if you look at the use chart, there are historic commercial zones.
Yeah.
There are downtown commercial zones, or they call it town commercial zones.
we only have mixed use zones. We don't have any commercial zones.
Okay,
If-
But-
if
No,
I
that's
remember-
commercial.
If I remember correctly, going back to the short-term rental work group, we were advised to do everything but CN because
CI,
everything but CI because there are short-term rentals in other places and we would have got into.
Yeah.
We were
Banning.
trying not to get into, oh, well, you need to account for every single reason.
That's right.
That's why it was putting Y in the use chart and regulate it in general bylaw. And obviously that's, there's a reason for that,
Yeah.
but now we have some new proposals, but that's what.
So I guess my question is, could we have consensus on the idea that a less than 31 day rental use could be allowed in both residential only districts, mixed use districts, but not in the commercial industrial district?
I want to look up those definitions before I agree with them.
Okay, that's fine. I'm not trying to trick you. I'm just saying like, so the residential only basically allow no commercial uses, and the mixed use districts are residential as a primary use or an accessory use, and then some level of commercial depending on where they are.
Erica, can you put the use chart up on the screen?
Well, you'd really have to see like what's allowed and not allowed.
It's only 6 pages long.
Right.
Maybe we could
Get
have that
that
as a
for
starting
tomorrow.
off point tomorrow.
Yeah, that's fine. I guess my question is, what zone is it that you would not want to see a short-term rental in?
It's not general short-term rentals. It is commercial short-term.
No, that's fine. I think we should deal with the commercial issue separately. I'm just wondering, is there a zoning district in which you would not want to see short-term rentals at all? I think commercial industrial shouldn't have them. Grant says the same thing. And then the other use, so, you know, and I'm not trying to pressure you. I'm just wondering, like, is there a zone that you can think of where we shouldn't have them? And if you want to answer that question tomorrow, you
I
know,
think she needs it tomorrow.
yeah, that's fine.
Can I ask a question of Dave Iverson
Grant, please, through me today.
through you? Dave, when we were talking about this, you mentioned CDT. Is that something you want to talk about, or
Well,
or am I just
I just-
misremembering?
No, I think I mean, listen, there's existing short-term rentals that's the downtown commercial district.
Yeah.
They exist there. It is a commercial district, so many people want to say it's a commercial use. I mean, so I would argue that it's appropriate there. I don't think that we
Where we
should,
have the hotels.
well, we have guest house there, we have hotels there. You could still permit a guest house in the CDT. So I think that that it's an appropriate location and shouldn't be overlooked.
Okay,
So what we should probably do is go right down the list.
Just this part, right?
well,
Go right across or go down or whatever you want to do.
so the town residential districts, that first third, basically allow almost no commercial uses. Right, so, but those are what you would consider the residential only
Yes.
town districts. Okay, and then the opposite side, the country residential districts are basically no commercial uses for the most part, not zero, but mostly none. And those are the larger, more rural districts. And so I haven't heard that we want to ban them from either of those.
No.
And then the one in the middle is except for the CI is mixed use, except for CI. So I guess what I'm saying is, I haven't heard anyone say, except for the CI district, that there's some area of the island or some type of district where they should be banned.
Not, well, I guess it's, some of it's shown there, but some of the other uses for CN, commercial
Yeah.
neighborhood, commercial island are apartment buildings.
Right.
Really dense, lots of traffic, lots of people.
Yeah. Hotels,
Yeah, commercial.
recreational facilities.
Anything with no setbacks and no parking requirements. I mean, these are really intense districts, whether or not you have short-term rentals there, they are intense. Short-term rentals are probably less intense than most of the uses in those districts. So,
I'd like to,
hold that. I will speak loud.
This thing on Zoom,
No, I get
they're
it.
saying it's hard to hear.
Okay,
I would love to know of those people that purchased, condos and apartments, how many of them are actually renting those short term? Because I've seen a couple, but I don't know if it's rampant.
Sure. Well, apartments as a use was only created like, what does it know, like 4 years ago. So that it's not like there's a ton of them around. I just mean that that's the other type of use that might otherwise take place in that area.
Mhm.
So
Yeah.
should it be protected from a weekly changeover? I don't
right.
think-
There's an intensity already. The short-term rental is actually probably less intense than some of the other uses. So I guess what I would say is we probably have a consensus that short-term rentals as a concept are something we want to add to the zoning code, and that no one has identified a zoning district in which they shouldn't be allowed except for the CI district, with the idea that we haven't ended that. You're still welcome to think about it and look at it more. Not trying to trick or fool anybody. I just want to identify if there was already something in someone's head of they shouldn't be here, let's hear it. And I'm not hearing that.
And just to the idea that we have some definition of not accessory, Nantucket short-term rental, something else that sand agency is going to. I think maybe a good idea would be to have primary short-term rental and put a no in every area. And then you have some other, maybe it's an unlabeled short-term rental. So that people can understand that there's a difference between the two and only one of them is allowed. So primary short-term rental would be with no restrictions, and that's a no everywhere. And that would be there just as a marker in the code to let people know that that's not something that we want to exist anyway. It's an idea.
I'm sure.
How would you define primary?
I would define it as short-term rentals with no other conditions attached, and there's somebody who
Right.
that.
It's just,
I-
it's just a business in a sense.
That's right.
It's
So
a
we'd say
short-term
it's a
rental business.
and then we'd say that's not allowed anywhere. And then we would put all the other regulations that more narrowly define the type of short-term rental that we would like. And that would be a completely separate use. And there'd be no confusing with the two.
Yeah, that's a really good idea.
Mr. Chairman, I promised myself not to express opinions for a couple of days, but I'm like that.
I think that's a good idea, Steve. And I-
That's a good exception. This one.
I'm gonna wait till the end, because I want people to.
So if we could prohibit sort of unrestricted short-term rentals everywhere, and then allow in all districts except CI and anyone else that someone wants to talk about the vacation short-term rental or whatever we end up calling it, and that will have hopefully all of the rules and regulations and limitations that hopefully we can get to here. I think that's a really strong way to move forward, and people, and it's clear, right? Okay, that's just something we don't allow, but this lesser, more regulated thing is something we do allow.
So, and
Victory.
yeah, I agree. So I just so you know, when we talked about this amongst our group, we thought there were two things we could call it. You could call it a vacation short-term rental, because Palm Springs calls theirs vacation rentals, not short-term rentals. And, or you could call it a Nantucket short-term rental, which is something that we embrace with limitations.
But I think the primary is very definitive. Nantucket is, where do I find out what Nantucket is?
Well, there's a definition in the zoning bylaw.
I see stickers that we could put on T-shirts and stuff.
But no lawn signs.
No lawn.
Thank you.
Okay, we can continue to work on the branding.
Yeah.
But I think, in 24 minutes, we covered a big issue with relative consensus?
Yes.
Okay,
I'm reserving.
yeah, I'm not trying to trick anybody, I'm just saying like, this is the most basic issue, if we can't move beyond that, none of the other stuff
Yeah,
matters.
it's a statement of principle.
Right, okay, so we all agree that on that.
You will send this chart out to us.
Sure, I can do that. It was in the warrant. I just pulled this out of the town
It's on the-
meeting
it's on the
warrant
website.
2024.
It's somewhere.
Because it's the.
If you could just send me a separate one.
It's also on the Fisher Real Estate website.
It's on the town, yeah,
Yeah.
I will include this in tomorrow's packet,
That'd be great because.
along with Jim's goals and objectives, which he had sent me and I didn't get in the packet, and Stevens.
I'll send it to you,
What
yeah.
did we call them? Concepts. And I don't know if you have anything.
So-
Writing, they will and the packet too, but.
So I guess
John Giorgio.
Yes.
Charity,
Right.
Charity and Matt, do you prefer Matthew or Matt?
You.
Okay, are you okay with the idea of using a Y for only the more restrictive term? You know, I'm
Pay
not,
tomorrow.
okay, that's fine. So I think, and again, I'm not trying to get you to commit to anything, but I think that that makes things work from a zoning point of view. If we have a no for primaries and a yes for our more restrictive term, and all of the things or some of the things that, you know, make people feel comfortable with it are in there. So it doesn't, you're not creating a pre-existing legacy situation for something that would then be hard to change because that allowed use was never the primary, unrestricted, whatever.
That's a good point.
That's a good point.
We'd have to see the definition, we'd have to come up with a good definition to agree with that on primary. And whatever we're gonna.
Yeah.
define
Well,
that
I guess what I would,
well.
yeah, I would suggest that the other one is
Why?
really where it
I
all
don't
did.
know. I wanna take a deep dive into every resident, I mean, ours is accessory, and that's what we really wanna stick by, and we want to A in those columns.
Yeah, I would suggest that the regulations create that accessory use in an effective way.
And if the
Why
goal
not?
is to create
What?
a compromise article, then we're going to have to settle on one thing and if people don't agree, and I don't expect everybody to agree on everything, then those people who don't agree still have their article that they can take before town meeting.
That's right.
So we all have a couple bites at the apple here. I don't think it's that difficult.
Yeah,
Just
I mean-
to clarify one thing, just ask a question that I don't think Stephen heard. The regulations are not separate from zone. Regulations can be in zone. So it's that high 2/3 hurdle to ever change.
That's right. I think that what we're likely gonna end up with is segregating rules that have to do with registration into chapter 123 and rules that have to do with controlling the use
Yeah.
into the zoning code, which is what I think John Giorgio wants.
Yeah.
And I think that that makes sense. And that's not how my article is written, but I think it makes sense to cut it up that way. And I think that
That's
if,
right.
if we come up with something that can be adopted at a 2/3 vote, that then seems really solid in the zoning code that has a lot of the rules that people want to, so that you feel like, okay, that is an accessory use or as close as we're gonna get. That's, you know, gonna be hard to change.
Not coming in closing. Till tomorrow, I'd entertain a motion adjourned, will be a little formal. Second, is there a second?
Are we back
Second.
here tomorrow?
We are back here tomorrow at 6.
No, we
Nope.
are not
Oh.
in this building tomorrow. We are Zoom only.
It's Zoom only.
Zoom only.
Zoom only. This
Stand
room
corrected.
is in use by 2 other committees.
Okay, are you, Erica, are you gonna send a link or is it just on the agenda?
It's on the agenda.
All those in favor?
Aye.
Those opposed?
Aye.
Thank you very much, everyone.
Thank you.
Thursday, we'll be back.
Thursday.
Pam, do you prefer Pam or Pamela? So I'm curious what your change is. Like, I read it, but like, what's your point of your change?
What?
What's the
my
point?
change
Yeah.
is the definition of investment entity.
If I go to the board website, I can't find any discussion about.
I-
The word corporation.
Yeah,
is
it's done.
defined.
Like, what are you trying to keep out that you think is currently allowed, I guess? is my
Because
question.
we.
Oh, yeah.
Partnerships.
Board of Health
Real estate
regulations.
investment.
Well, they're the
And the
regulations.
real money's